Perfect. Looks great.
Awesome. Okay, we're ready to go?
We are ready. Go ahead and take it away.
Okay. Thank you all for joining us this cold, snowy afternoon. Today we are going to be discussing claims management. So we'll hit on our agenda really fast. Do a little bit of introduction. We'll talk about claims reporting. We'll also go through some claims milestones through the life of the claim from inception to closure. We're going to talk a bit about IMEs versus DIMEs, so independent medical examinations versus division independent medical examinations. And then we'll finish up with closure of a claim versus settlement of a claim. Okay, so my name is Liana Dyson. I am Pinnacol's claims education owner. I have been with Pinnacol for 29 years now. And my primary job is to train either externally or internally claim reps, policyholders, agents, whoever may need any type of claims training. I'm your gal. So a little bit of trivia. Anybody have any idea which country was the first to enact workers' compensation laws?
Denmark.
Oh, good guess.
Yugoslavia.
Oh, Yugoslavia. Okay.
Terrible.
Actually, it was Russia. Russia passed its first employer's liability law back in 1871. And it was pretty narrow because it only limited certain or protected certain occupations. And then in 1884, they passed a workers' comp law that's similar to what we see today. And Wisconsin was actually the first state in the United States to implement any type of workers' compensation law. Okay. So let's talk about a claim. An injury occurs, what do I do now? Hopefully you don't have so many claims that you become an old hand at this and you know exactly what to do. But when an injury occurs, the first thing we want to do is report that claim immediately. The earlier, the better. This helps us identify witness statements. It helps us to make sure that we're giving the injured employee the designated provider list. So that designated provider list is a listing of 4 providers. The injured worker gets to choose one of the 4 providers in which to seek care with. The policyholder only has 7 days to provide that designated provider letter and that list. If we don't, the injured worker can go to whoever doctor they want to. That could be a general practitioner, a family doctor, a chiropractor, a massage therapist, anyone they decide they want to treat with, they get to do that. Unfortunately, when that happens, we lose quite a bit of control over the claim as far as helping to organize medical treatment, prescriptions, work restrictions, getting an injured employee back to work as soon as possible. We have data that shows us that claim costs go up quite a bit when an injured worker chooses their own doctor. We want to report as soon as possible as well so we can get the injured worker treatment as soon as possible. We report it if they need to be seen in the emergency room, absolutely, get them that emergent care. If it's not an emergent basis, let's try and get them in with that designated provider as soon as possible. If they do have to go to the emergency room, however, what we want to make sure that we let them know is that ER visit will be covered. However, all of their follow-up care needs to be with that designated provider. Sometimes we see an ER doctor make a referral to a doctor that they know that's not within that designated provider network, and we have to kind of reel back and rein the treatment back in. Another important point to make when a claim occurs is preserving the evidence. So if you have a piece of equipment fail, if a conveyor belt is faulty, if a scaffolding collapses, and there's a possibility of a third party being at fault for that, we ask for you to go ahead and preserve that evidence. Don't call the product company saying, hey, your machine broke down, it injured one of my guys. The first thing they're going to do is they're going to offer to come out and fix it or replace it for you. And if that happens and we lose that chain of evidence, we may not be able to pursue third-party benefits for that. So what is Pinnacol doing after an injury is reported? So for certain claims, not all claims, but for the majority of the claims, we're going to contact both the policyholder and the injured worker. We know that contact as early as possible is the most beneficial because facts are fresh. We can help with coordinating that care, and we can also help from the date of injury to help identify and organizing a modified duty offer for your employee. We're also going to obtain witness statements, medical records, get copies of any surveillance video. Maybe we'll do a social media sweep, anything that we may need to help us determine whether or not a claim is compensable. So if after the investigation, after we gather up all the facts, if the claim is not compensable, Pinnacol will deny the claim, and we will notify all parties of the denial with an explanation as to why the claim has been denied. If there's no coverage or the claim was not work-related, it wasn't in the course and scope, something along that lines, we're going to go ahead and explain in detail as to why Pinnacol is denying the claim. So on the other hand, if the claim is compensable, what we're going to be doing is filing what's called a general admission of liability. And basically what that says is that Pinnacol is admitting liability and we will pay specific benefits. A general admission of liability is not a guarantee of all benefits, only the benefits that the injured worker is eligible for. So one of the benefits we may pay is lost time benefits. An injured employee is eligible for lost time benefits after they miss 3 working shifts. The keywords here are working shifts. So if I work 9 to 5 Monday through Friday, I would need to miss Monday, Tuesday, Wednesday before I was entitled to lost time benefits. But where it gets a little bit dicey is if I don't work a traditional Monday through Friday schedule. If I'm a firefighter, a volunteer firefighter, a paramedic, a nurse, it's not uncommon for them to work 24-hour shifts. So in order for them to be eligible for lost wages, they'd have to miss 3 24-hour shifts before they were eligible for benefits. Once we start paying lost time benefits, we must continue those until they either return to work full-time, full wages, or reduced hours, reduced wages, or they're released to full duty by the doctor. Okay. We will also pay medical bills. It's important to note here that we pay pursuant to the Colorado work comp fee schedule, and a provider cannot bill an injured worker for a balance due. So if I go to the doctor and the doctor bills Pinnacol $1,000, if the fee schedule says that we pay $100, Pinnacol will pay the provider $100 and they have to accept that as full and final payment. I cannot get a bill for $900 balance due, because once you take on an injured or Colorado work comp employee as a patient, you agree to accept that fee schedule. We're also going to reimburse the injured worker and the policyholder and you, the employer, for any out-of-pocket expenses, such as maybe you had to pay for some prescriptions, maybe we needed crutches or a wheelchair or something that was paid for out of pocket. We'll go ahead and reimburse for that. Once the claim is compensable and we're paying benefits, it's Pinnacol's job to monitor the medical care and the treatment to ensure that the injured worker stays compliant so that they're attending all of their medical appointments, be it doctor visits, physical therapy, acupuncture, whatever that may be. But then we also want to make sure that that claim is moving towards closure. And one thing that we're aiming for is for the doctor to find an injured worker to be at maximum medical improvement. That basically means that an injured worker's condition has stabilized, that no more care can improve or better their condition. We don't have to relieve and cure the entire condition. We just have to get them to that plateau, to that baseline. We're also going to be working with our policyholders and the injured worker on return to work options. I highly, highly recommend that even if you have an employee who voluntarily returns to work, that you go ahead and still do a formal modified duty offer. Because we have seen where a working relationship starts out well, they come back to work, but maybe they're getting advice from outside sources. Maybe they don't like the modified duty work that they're doing. And so the injured worker just decides they're not going to do it anymore. Well, unless we have that formal modified duty offer in place, we have to keep paying that injured worker, even if they've stopped coming to work on their own. We have to continue paying until we get a formal modified duty offer in place. So I always encourage my policyholders to go ahead and still do that Rule 6 job offer for them. Okay. So the employer, policyholder, what should you be doing while your injured employee is off of work? I think the biggest point I can make here on this slide is staying in touch with their employees. I've had conversations with injured workers who obtained attorneys, and when the claim was finally done, maybe they called for something, I would ask them, I thought things were going well. Can you tell me what made you decide to get an attorney? The number one reason that they had is, I've been off of work for 3 months, 2 months, 6 months, and I've yet to hear from my employer. They don't care about me. I'm just a number. Staying in touch with your employee helps them feel like, yep, we care about them. We're vested in their improvement and they're getting back to work. And it also allows us to stay connected with that injured worker. Maybe they have questions or concerns that they're not comfortable asking Pinnacol, but they're comfortable talking to you about it. We can sometimes get that information that way. Pinnacol has a lot of resources on our portal. If you go to the policyholder portal for Pinnacol and look for resources, we have get well cards that are free of charge. You can order them, keep them in file, send one every now and then to your injured employee. We have claims information folders that allows you to keep track of who the claims adjuster is, who the doctor is, important phone numbers, appointments, medical records. You can keep them all in a manila folder. We have those available as well. So once we have that claim going, notify the claim rep if anything changes. If they've gone back to work, if they were fired, if they resigned, if they retired. Let us know that, because that may change the type or amount of benefits that they're entitled to. But also let us know any questions or concerns you or your injured employee may have. Expect to be kept up to date. If you're not actively hearing from your claim rep, let us know that, because we should be actively sharing information with you. And the last important thing we want to point out is identify and work towards getting the injured worker back to work as soon as possible. We have data that shows us that if an injured worker remains off of work for 6 months or longer, the likelihood of them ever returning to work drops by 50%. Okay. So why do we care? Why do we care about getting them back? Well, one of the reasons I just talked about is the longer they're off, the less likely it is for them to ever go back to work. It helps keep the costs down, which in turn keeps your EMOD down, which in turn helps keep your premium down. But another big one is it helps keep the injured worker from getting deconditioned. So I have a back injury, and because of my back injury, I'm on restrictions. My employer can't meet those restrictions, so I'm staying home. And I stay home for 4 months. And then the doctor releases me back to full duty. Well, I've been sitting on my couch for 4 months, haven't been really doing any activity. There's a good likelihood that I could re-injure myself because I've been off of work and I've become deconditioned. Okay. So what is your claim rep doing? We're going to be contacting the injured worker regularly, every couple of weeks if they're off of work. My message to my injured workers was, your job right now is to just get better. I'll be calling you every couple of weeks, making sure that you're doing okay, that you're getting the checks that you need. Right now, all we need for you to focus on is getting better. We're going to be obtaining medical records. We're going to be coordinating medical appointments and medical care. So if the injured worker needs a referral to a specialist, we're going to be helping with that. We're also going to be pulling in any other resources that will help us manage the claim. That includes our SIU department, our investigations department. So if I have a policyholder who thinks their employee is working for someone else while collecting, we might set up some video surveillance on them. Maybe we need to get a prior medical record from a pre-existing condition. We can ask SIU to get involved with that to help us get that information. If a claim becomes medically complex, we may involve a medical case manager. So they'll kind of become the gatekeeper, make sure that medical treatments and records are going to the correct people. And we may have to get our legal department involved. If, let's say that I have an injured worker who's not going to medical appointments, or they've been terminated and maybe we need to stop paying them lost time benefits, we might have to get our legal department involved with that. So how do we move a claim towards closure? Obviously, the claim rep is going to be monitoring those medical records. We're going to make sure that they're attending all of their scheduled appointments. If they're not, we do have the right to set demand appointments for them. And there's some rule written in to the work comp law that says if an injured worker fails to attend 2 demand appointments, that we can start moving the claim towards closure. Another thing that we might do is we might get that second opinion or that independent medical examination. We may need that for a number of reasons on the claim. So what is an IME? What is an independent medical examination? It's a second opinion. It's different from the division IME, and we'll talk a little bit about that a little later. An IME can be with any doctor of any specialty of our choosing. So if I want the injured worker to see a neurologist, I can choose Dr. Reichard to provide an IME for us. An IME allows for us to write a letter to the provider, to the doctor, with very specific questions. I can call the doctor on the phone and say, hey, here's a little more information that we think might be important before you see worker X. Or we forgot to put in the letter, but we would like for you to address impairment or something like that. We actually have the ability to contact the doctor and communicate with them in several different ways. We can get an IME for a multitude of reasons. Maybe we need to know when the claim is going to close. Maybe we need to know if their injury could have indeed be caused by their work activities. Maybe we are arguing or disagreeing with a particular type of treatment or a body part. So my injured worker had a claim that started as a knee, but now all of a sudden they're wanting to treat with the back. We may get that IME or that second opinion to address whether or not it's reasonable for the back to be related to the type of knee injury that they have. We may want to dispute the necessity of a certain treatment. So we get a prescription from a doctor for a hot tub, or we get a prescription or a request to do a 3-level spinal fusion. We might get that second opinion or that IME to determine whether or not that requested medical treatment is really necessary. An IME could be for permanent impairment. Permanent impairment is a permanent disability that an injured worker sustains because of their injury. Maybe the treating doctor gave them a very high impairment rating and we want to dispute that. we would start possibly at a second opinion or an IME. And then we can also request one for work status. Is the injured worker able to work? Will they ever be able to return to work? We'll see a lot of independent medical examinations when we start talking about what's called permanent total disability, when someone is alleging that they can never ever go back to work. So these are just some of the reasons and how we would be able to use that IME option on management of our claims. The other type of second opinion is called a division independent medical examination. This is much more narrow as to what we can do and what we can use that DIME for. So a DIME is a panel of 3 doctors. Those 3 doctors sit on a panel that's been outlined by the Division of Workers' Compensation. Both sides of the claim gets a copy of those 3 doctors. Pinnacol gets to strike a doctor. The injured worker gets to strike a doctor. Whichever doctor is left is going to be the doctor that's going to perform that second opinion or that DIME. You can only go to DIMEs for specific issues. Only maximum medical improvement, permanent impairment, or apportionment. All those other things that I listed in the prior slide, causality, reasonable relatedness of treatment, a DIME doctor cannot address that. They have to stick with these particular issues. And then Pinnacol can't communicate with the doctor. I can't write a letter to one of the DIME physicians asking them to clarify something. I certainly cannot call them. All communication has to go through the Division of Workers' Compensation, and there can be no ex parte communication by either side. And the big difference here is findings of a division IME are binding. The only way that we can argue or go around a DIME is by going to hearing. And even then it becomes very difficult because it has to be clear and convincing evidence or proof that we set forth before we can try and overturn any findings from a DIME. So you'll very often see Pinnacol first start at the independent medical examination, and then the DIMEs tend to be towards the closure of claims when we're starting to argue about permanent impairment or apportionment or things like that. Okay. So once I have an injured worker back to work, the claim is not closed. That's not the end of the claim. And this is important for us to get across because some of our policyholders think that once an injured worker is released to full duty, that their claim should wrap up. But it's very common for an injured employee to get released back to work and treatment continuing for a good deal of time before they're released to maximum medical improvement. What's also important to note is that treatment can continue even after they're at maximum medical improvement. This is what we call maintenance medical care, and it's treatment that an injured worker would require to keep them at that plateau level, at that baseline level. It could be periodic massage therapies for the next 6 to 9 months. It could be a lifetime medication refill, but those are considered maintenance medical care benefits, and they would not stop the claim from closing. So how do I get that claim closed? We have a few ways. The first way is it can be a release from care by the doctor. When that happens, the doctor has to assign what we call an MMI date. So they have to say, okay, Liana, as of January 15th, 2021, you're now at maximum medical improvement. You're now at MMI. They also have to address at that same time whether or not there's any permanent partial disability. And that's usually a percentage, and that percentage is exactly what it says, a permanent disability. Maybe they've lost the ability to turn their neck fully. Maybe they've lost some range of motion in their back. The doctor will run them through some measurements and assign a percentage of impairment. that Pinnacol then has to turn around and compensate them for monetarily. The other way is settlement of a claim. This is truly, truly the only way a claim closes completely and forever. This is different from a final admission of liability because an injured worker can come back and reopen a claim within a certain number of years if they have a worsening of condition or anything like that. A settlement is a set amount of money that Pinnacol pays the injured worker, and they forever waive their right to ever reopen the claim. So they're sometimes given money for what we call waivers. So that's a little bit of extra money, which basically is just that, them waiving their right to reopen. And then the final way that we can close a claim is legally. We can file what's called a motion to close. A motion to close can be used when an injured worker isn't going to the doctor, or maybe they'll go to one appointment, but they'll skip the next 3. Maybe we find out that they are self-harming to drag their claim out. We can file what's called a motion to close, in which the injured worker has to basically give a good reason why their claim should remain open, or else the Division of Workers' Compensation will order the claim closed. And then from the legal perspective, we can always go to hearing. So if I have that injured worker who is self-harming or is refusing to attend medical appointments or second opinions, we can go to hearing and ask a judge to allow us to close the claim as well. So key takeaways. For the employer, report the claim as soon as possible. Even if you don't have all of the information, it's okay to follow up and provide that additional information, but let Pinnacol get started investigating the claim as soon as possible. Stay in touch with your injured employee. Utilize the free resources that Pinnacol has online. Set a calendar reminder for yourself to call your employee every couple of weeks just to check on them. Identify modified duty as soon as possible. If at all possible, identify modified duty even before an injury occurs. Our return to work consultants are available to come out to a policyholder's place of business and help you come up with modified duty jobs way before a claim even happens. And then actively share any information with your assigned claim rep. So if you've learned that they are supposed to go on a hunting trip over the weekend, but they have a no standing or no long distance walking, share that information with your claim rep. If they've gone back to work, share that information with your claim rep. Any information that may impact the claim, get it over to us as soon as possible. And Pinnacol is going to be investigating the claims as quickly as possible, administering those benefits as quickly as possible. We're going to make sure we're coordinating the medical care, working on return to work options, making sure that that claim is moving to closure and it's not just become stagnant. And then share actively information with you, the policyholder, and the injured worker as it comes up. So keep all parties informed as much as possible. And that's it. That's all I have. Are there any questions? Anything I can answer?
I'll take a stab at a question real quick.
Okay.
Communication with the employee by the employer. I know employers in most cases will want to do everything they can to help the employee and help with their recovery.
Mm-hmm.
When or how does an employer prevent going too far, making, maybe promises they should be making, or attempts, you mentioned getting information for the employee or that, where is that line? You want to help, but don't be too much help.
Yeah, that's a great question. There's definitely a line that you can sometimes straddle where helping, gathering information turns into directing medical care, perhaps. So you're entitled to specific medical records that as they relate to the work comp injury. You can call a doctor for clarification of something. So let's say that the doctor releases your employee to restrictions and you're not quite sure what those restrictions really mean. It's okay to pick up the phone and call the doctor and ask the doctor. What you don't want to be doing is you don't want to be scheduling the appointments for them, going with them to the appointments, unless they ask you to. I have some employees who would have their boss go with them, telling them what doctors they should go to or telling them what doctors they weren't allowed to go to. So whenever you're not sure if maybe you should do this or can you, just give us a call. We're more than happy to talk you through that and give you some direction.
Okay. Should the employee decide to retain counsel, does it become necessary on behalf of the employer maybe to limit the contact that they have from that point on?
Yeah, that's a really good question as well. There does have to become a limit of what you can discuss with your employee. You don't want to talk about any type of benefits. So let's say that they come to you and they say, Pinnacle's not paying me enough money. Well, unfortunately, you have an attorney, so your attorney is going to have to call Pinnacle to clarify that for you. You can still talk to them about how they're healing, how they're feeling, things like that.
Mm-hmm.
You just don't ever want to give the appearance that you're trying to impact or influence their recovery or their benefit.
Okay.
Yep. Great question.
Liana, this is Kay Mitchell. Oops, sorry.
Okay.
Yeah, that's okay. Just had a quick question also in regards to, earlier on you had said that part of the investigation may be looking at the social media, and I have had clients in the past that have either they or their employees are stalking the social media of whoever is out injured because of knowledge behind, the person's personality or whatnot. So do you all continue to monitor social media on the cases? Is that something that you think is a wise thing? Is that something that can get them in trouble?
Right. No, we won't monitor it. What we may do is, let's say that you report an injury, but the policyholder has some questions on it that maybe this person was injured doing something outside of work. We might go on and do a social media search to see, did they post about their softball tournament that prior weekend or the hunting trip the weekend before. We won't keep going to their social media, kind of like hoping they're going to slip or something like that. We'll usually use those social media sweeps when we think that it's a working while collecting situation, or that maybe somebody is malingering or exaggerating their symptoms. But no, you definitely can run into, the allegations of harassment or retaliation of a claim filed if you have somebody just constantly monitoring and peeking and looking at someone's social media, for sure.
Okay, thank you for that. I thought so, but I'm not an attorney, so wanted to know.
Definitely.
I'll throw one out there. Given the current times, an employee comes in and says, I just tested positive for COVID. Does that immediately become a workers' comp claim or a standard health claim?
Great question. So it depends on where they got the COVID.
Okay.
So
if they insist they got it at the employer, then who has the burden of proof?
So what would happen is, and we've actually gotten slammed with COVID claims. We would have the policyholder report the claim. We do have very specific questionnaires that we have the injured worker and the policyholder fill out. And and part of the injured workers questionnaire is a 14-day tracking. What have they done? Where have they gone for the past 14 days? So they have to show that there's they came into contact with someone who was COVID positive. So a claim would not be compensable if they think somebody at work gave them COVID. If they cannot point to a direct source, it would not be a compensable claim. We treat COVID as any other infectious disease, chickenpox, tuberculosis, anything like that. You have to show a direct contact with someone that caused you to become infected.
Okay.
I've got a question, and maybe Tony, even this might be helpful for you, but I know here in Iowa we've got a lot of, and especially pre-pandemic, where it was very hard to find qualified workers. We had a lot of border towns where somebody would all of a sudden become available. And perhaps not long after the person started work, they were injured on the job. And after an investigation, we'd find that they were actually already collecting workers' comp in Minnesota or Nebraska, but they just so happened to all of a sudden be able to start working just across the border in a different state until they have now hurt themselves again, oftentimes the same way, and want to collect workers' comp again. Is that something that you guys see often? Is it something that do groups talk across state lines about that kind of stuff? And I guess I'm just kind of curious. I mean, are people able to double dip? It just kind of depends on the states, or what?
Yeah, great question. Depending on the industry, we do have some industries that are very nomadic. Our farms, so a lot of our workers are migrant, and they'll just go from farm to farm depending on what season. Is it potato season, onion season, wherever. So it could take them back and forth from Denver or from Colorado to New Mexico or wherever. Our natural gas industry on the western slope, we have a lot who will kind of toggle between Colorado, Wyoming, Utah. So it depends. It depends on the state. So certain states will allow you to claim benefits in either state. You have to pick one or the other. Mm-hmm. I don't know of any states that allow for double dipping. What should occur is if I file a claim in Illinois as well as Denver, and I'm getting paid work comp benefits from Denver, Illinois should be able to offset whatever that Colorado insurer is paying. So I'm not aware of any state that allows double payments. Mm. And, you're also, you're only as strong as the information you can gather. So sometimes it's really, really hard for us to get any information from other states, especially monopolistic states where they're the only show in the state. They may not share that information with us. So it could be a little bit difficult that way as well.
Since I cover Wyoming also, in Wyoming being a monopolistic state, how are they to work with?
They're actually not bad. They're actually not bad, only because we've had such a long relationship with them.
Okay.
And I think those workers that will go back and forth, they learn very quickly which state is going to pay the better benefit. So whichever state is a little more generous is usually where you're going to see the claims filed. But, you also have to remember there's very specific criteria for someone to be deemed a Colorado employee. True. And you have to be a Colorado employee to be eligible for work comp benefits. Mm-hmm. So I've really not had any problems working with them.
Okay, great. That's good to hear.
Yeah.
All right. Any other questions? All right. Well, hearing none, Sylvia, who I don't think can still hear us, but she has emailed me the PDF of the PowerPoint slide, so I will go ahead and send that to you folks. And in addition to that, we will try and get this recording along with our last one posted onto the website at some point in the near future. So having said that, this is our last one. I do want to, on behalf of Tony Gagliardi and myself, thank Sylvia. I wish she could hear us. Liana, please tell her thank you for us. And thank you so much as well. Everyone at Pinnacol has been fantastic to work with this entire time. And this has been very informative information for our members.
Oh, it's our pleasure. Thanks, guys. I appreciate it.
Thank you.
Bye.
Bye-bye.